Good afternoon, friends. Important circular for Rule 96 Sub Rule 10, which is coming out as per the recommendation of GST Council, meeting held on 9th of September 2024, 54th GST Council meeting. The context and background. Simple. In terms of Rule 96 Sub Rule 10, if you're an exporter, and you have imported input availing concessional or exemption notification against advance authorization or EOU, meaning thereby while importing you have not paid IGST or compensation cess as applicable. But subsequently, you have manufactured the goods from those inputs and exported, and you have applied IGST on export and taken the refund of IGST charge on export, zero-rated supply. As per Rule 96 Sub Rule 10, there was a provision, specific provision, that if you are availing such a concessional or exemption notification benefit, you're not paying IGST or compensation cess as applicable on import of inputs under advance authorization or EOU, you're not allowed to export on IGST. This was the restriction. But the circular is now clarifying and making regularization as its where-age basis. Please try to understand. They are saying that if you have availed the exemption benefit, not paid IGST and compensation cess, and applied IGST on your zero-rated supply and taken the refund, then it can be regularized provided first you pay the IGST or compensation cess as applicable on original bill of entry duly reassessed as the jurisdictional custom authority by the jurisdictional custom authority. So you will pay up the IGST or compensation cess along with interest on original bill of entry duly reassessed by your jurisdictional custom authority. Then it will be considered as if you have not availed the benefit of that concessional or exemption notification. Hence, thereby, the barring provision of Rule 96 Sub Rule 10 is not going to be applicable to you. So you're allowed to make export zero-rated supply on payment of IGST. This is what the crux of this particular circular. Let me share the screen and show you the relevant provision so that you get a clarity. The circular number is 233 dated 10th of September 2024. And they are clarifying the position that how it should be read and in what context it should be read. So I'm just reading this context for all of you so that you get a clarity that Rule 96 Sub Rule 10 provide a bar on availment of refund of IGST paid on export of goods or services if benefit of certain concession or exemption notification as specified in said rule have been availed. So under advance authorization or EOU, if you have availed the benefit, then you can't make a zero-rated supply on IGST. So question was whether refund of IGST, if you have done so, you have charged IGST, taken the refund also by the registered person can be regularized. In a case where registered person who is exporter in India had initially imported input without IGST and compensation cess, by availing the benefit of notifications number 78/2017, 79/2017, but subsequently at a later date, said person has either paid the IGST and compensation cess along with interest on such imported input or is now willing to pay So either you have paid or you are now willing to pay such IGST and compensation cess along with interest whether your such refund of IGST can be regularized. This was the issue which is being clarified by way of circular. They are picking up a context from notification number 16/2020. An explanation inserted in sub-rule 10 of Rule 96 retrospectively with effect from 23rd October 2017. And it is worth reading because this is the basis this circular is got issued. As per explanation, for the purposes of this sub-rule, benefit of notification mentioned and therein shall not be considered to have been availed only where registered person has paid IGST and compensation cess on input and has availed the exemption of only basic custom duty under the said notification. So if you have paid the IGST and compensation cess along with interest, then it will be termed as if you have not availed such exemption notification benefit. It is only with respect to BCD, basic custom duty. So taken this context in a mind, they are now concluding accordingly refund of IGST claimed on export made with payment of IGST in such cases may not be considered to be in contravention of the provision of sub-rule 10 of Rule 96 of such CGST rule. This is what they are clarifying, and this is the context. This is what it is coming out. That's all. This is what the circular is talking about. So it's a good, laudable clarification, and a lot of dispute which is going on either by way of so-cause notice or pending before adjudication officer, or if you want to avail the benefit of this circular is saying if you're willing to pay, then also you can regularize your IGST of which you have taken refund on zero-rated supply by paying IGST and compensation cess if applicable along with interest by getting your original bill of entry reassessed by the jurisdictional custom authority. Thanks for watching. Stay tuned. Lot more. Thank you very much.